Hi, this is Victor. I'm going to talk about why it's probably a bad idea for an in-custody defendant to have all of their discovery, or even part of it. I realize the in-custody defendants are not going to be watching this video because, well, they're in custody. And I hear that they don't let them play on the internet in the jails or the prisons. But I'm hoping that some family members will watch it and will understand so that they stop asking for discovery. An in-custody defendant who receives discovery is often going to become confused, convicted, or killed. It's bad. Let me go over some of the reasons. Confused. Often the in-custody defendants look through their discovery and, well, I shouldn't say often, I should say all the time. They look through their discovery and they find out that there's missing pages. Pages are missing. Things are blacked out. They think, oh, the police are hiding something. Well, maybe the police are hiding something, but the odds are the pages are missing because their attorney or the investigator took the pages out. Because the attorneys and the investigators are not allowed to give witness identifying information that allows the person to contact the witness. Therefore, the attorney and the investigator are going to be removing things like addresses and phone numbers. Other rules require that they remove financial information such as credit card information and social security numbers. So there's going to be a lot of stuff in the discovery that's missing, and it looks like the police may be deceiving, but that's not the case. They may be deceiving in other areas, but redaction is not deception, it's just the law. The police reports may also have summaries of recorded statements, and the police will take a recorded statement from the defendant. It may be an hour long, it may be 2 hours long, and they're going to write a short summary. They're going to give their interpretation as to what happened. Now, the in-custody defendant reads this and says, oh my God, they're lying. I didn't say that. They left all this out. Well, it doesn't really matter what the police report says when there's a recorded statement. It just tends to confuse the defendant. The recorded statement is the recorded statement. We can listen to it. We can have it transcribed. We can know exactly what you say on a recorded statement. The summary that's prepared by the police officer, it's nice to know what he's thinking about it, but it's not really the evidence that's going to be presented at trial most of the time. If he does come in and he says something contrary to the actual recorded statement, the attorney can impeach him with it. Another area of confusion is the reason for the search. This comes up fairly often. The defendant will say, it says here that I was on probation. They can't search my house pursuant to a probation search because I wasn't on probation anymore. But if we look a little further in other areas of discovery, we might find out that they had many reasons for search. They may have showed up to do a probation search thinking that someone else was on probation. They may have thought that the defendant was on probation. But once they got there, they may have seen something in plain sight that gives them probable cause to enter. They may have seen something that gave them exigent circumstances. They may have found out that someone else was on probation. It causes kind of a problem when the client is arguing with the attorney saying, I wasn't on probation, they had no right to come in and search, and the attorney looks at it and says, yeah, they had a lot of reasons to search. Let's move on to some issues that can actually prove your innocence or some issues that can actually get you off on the case. It doesn't really do any good for the defendant to read through the discovery and then argue with the attorney on things that are legally insignificant. If the police report says they arrived at the scene to do a probation search, but you weren't on probation, but you happen to have signed consent to search, it doesn't really matter. It's just confusing the issues and distracting from your defense. Having all the discovery can also lead to you getting convicted in several ways. One, a person who has all their discovery is often tempted to chat with other inmates about it. And sometimes these inmates want to make a good deal. So they may snitch. You may be chatting, the defendant may be chatting. The defendant may be chatting with another inmate in confidence saying, you know, this is what the police said, but this is what I really did. And that inmate may want to strike a pretty good deal by saying, hey, you know what? My celly's guilty, and he told me about it. It's also tempting to talk about it on the phone with your friends and family. You read the discovery, your friends and family receive your phone calls, and they say, well, what did the discovery say? And the defendant tells what the discovery said, and that can be interpreted as a confession. The defendant may say, well, I went into the store, I pulled out a gun, I stuck it in the cashier's face. They may be reading from a police report, but in a dry transcript, it may sound like a confession. And that confession may be used against the defendant. Even if the defendant doesn't chat with anyone, that doesn't mean that the police reports are not going to work their way into the hands of their cellie or guards or even other inmates. A cellie can read the police report, pick out a few key pieces of information, and then turn snitch and say, well, I was told by the defendant that he did this. And they can pick out enough information that only the defendant would know, or the police, about the crime scene, that they sound very convincing, and they can strike a pretty good deal with the prosecution in exchange for testifying against the defendant. The third, and probably the most major, depending on one's point of view, is having discovery can get an inmate killed. It's not just the molestation cases. Inmates do tend to kill molesters. They beat them up. They fight. It's wrong, but they do tend to be aggressive towards someone accused of molestation. But we also have the problem of gang attacks. If the discovery shows that the victim was a member of a certain gang, other members of that gang may want to retaliate. It may even be just a friend. The police report may show a friend of some other inmate, and they may want to retaliate. And from time to time, this actually comes up a complete mistake. Someone will glance at a piece of discovery, and they'll think that they saw something in there that really wasn't in there. A fellow inmate may see something in there, and they may say, you know, that looks like a sex offense. That I think that was my homie. And unfortunately, sometimes people get killed on mistakes, and there's fewer mistakes if there's no discovery for those inmates to look at. In short, discovery can confuse, convict, or kill. Sometimes it's better just not to have it.